Yeah, thank you, BW, for allowing us to do this discussion. And I think the topic is very wide, and the discussion around it could be also surrounded on many issues. But we will try our level best to ensure that we stick to, the timeline as was indicated. And of course, since we are joined by experts on various fields, I think it'll be interesting to have some ideas about what went around in the year 2025 in terms of how the laws have been made or the issues that as a country we have surfaced or faced. And I think it'll be equally important to also understand that what are the things that we need to look at from the standpoint of going ahead in the year 2026. So to begin with, and of course, in the age of technology, in the age of media, the one most fat topic which everybody seems to be concerned about and or talks about is AI. And I think it has been extensively being used. It's no secret that it's been extensively used in every field, be it law firms or be it courts. Now even the Supreme Court talks about there is a app called Supace where they are streamlining and trying to ensure that the filing or the reading of materials becomes a lot more simpler for courts, for judges in the Supreme Court and even in other courts. So streamlining documents and wanting to take care of high bulky files to read. So I want to jump onto this topic and talk to maybe Rohit to begin with, that what is his views on the AI and the usage of his AI in the legal world.
Thanks, Varun, and thanks, BW, for having me. Um, with AI, I'll just give some statistics first before with the innovation and technology and AI, there's a lot of positives also, but it is a big challenge for cybersecurity also. In the past year, we faced around 36 lakh cyber attacks, uh, causing more than 22,000 crore losses. That is the uh, volume of cyber attacks and losses that we are looking at. So coming to the point, what in India especially, and since it is a borderless crime, so it has to be uh, looked in a way that when we are implementing something or any laws are there, it is covering everything. So first is AI. I think all the laws governing IT and cyber security goes back to IT. Then there is no central act. We have a digital bill that is coming up, and we have fragmented governance. We have by MITI guidelines, RBI, SEBI. Everyone has their own guideline.
Correct.
So the just one thing, then you can jump on to the next question. So the issue that is still arising is for companies to follow everything, and it is cost heavy also.
Correct. No, actually, in fact, not just that. I think synchronization of laws and how it affects companies is, of course, is a widely talked about subject, because the manner in which either any company has to fulfill its compliance is very, very difficult, and the lack of synchronization does take a huge impact on them. But actually, I want to take this topic forward where, in the year 2025, or in fact even in 2024, we have widely discussed and talked about the consolidations of, the criminal law in our country. And I want to ask Shalini your inputs about how do you see that as a boon or a pain for our country as in date?
Hi, everyone. Thanks, Varun. Not just criminal laws. We see the new labor code being implemented in parts, of course. And we see many other regulations, like we are talking about AI, and there are regulations on dark patterns. Now, who knows what dark patterns is? But it is something that exists in the e-commerce world. And again, people are conned. There are two faces of the story everywhere.
Correct.
But yeah, consolidation, I think the legal landscape in India has really matured now. Now, what we should look at is the implementation of that matured setup that we have. We talk about arbitration laws. I think it has been amended time and again, the laws, the statute, and we are at a place where we are pretty equipped to handle international arbitrations, to have great institutions in India and make India a dispute resolution hub. But it all depends on the judiciary and the bar as well on how we take it forward now.
Right. Actually, you raise an interesting point about implementation, and I think most of us who are litigating lawyers, we do see that a lot of laws are actually, made but not implemented. In fact, when you talk about labor code, I know for a fact that I've done work on labor issues where you've seen that labor code was actually enacted in 2020, but in 2025, it's been, for the first time, it's been said that it's been notified. But I want to get Sumer into this because the one aspect about implementation of law is that it has very wide ramifications. And of course, we saw that, considering Sumer knows environmental law really well, I want to throw a question in the environmental sector that, we saw that there was a step forward taken from One Shakti judgment where there was a decision taken that post facto clearance should not be allowed, but that's again been now turned back. How do you see that impacting the systems in such like in the implementation of projects? How do you think that will be impacted with this judgment?
Thanks, Varun, for the question. Hi, everyone. So it was not unprecedented what happened in Supreme Court, but it happens rarely. Just to give you a brief background of what the issue was and what happened. Under Indian environmental law system, what you need before you start operations of an industry is a prior environmental clearance, the most important word being prior. The government came about with a couple of circulars, one in 2017 and later on in 2021, whereby the government allowed the industries to get post facto environmental clearance. This is what was challenged in One Shakti by the petitioners. And the Supreme Court this year, I think in May, struck down those circulars on the ground that the concept of prior environmental clearance is not followed, and therefore we don't agree with what the government is wanting to do. Later on, CREDAI, being the head institution for all real estate developers, went as an association to Supreme Court, and Supreme Court thereafter sort of set aside the judgment passed by Justice Oak in One Shakti and said that, look, this is not sustainable development. What sustainable development means is that you have to look at the interest of all the developers as well. There are too many infrastructure projects which are in question. And therefore, to balance it out, Supreme Court said that we are going to, in exceptional circumstances, allow post facto environmental clearance. And therefore, the two circulars that were initially challenged were brought back in force. What impact it is going to have on the projects? Of course, it's a boon. The share market, I'm sure, did very well after that judgment was passed. But if you ask for my personal opinion, I think somewhere we have to look within ourselves and ask ourselves, what is it that we want? Do we want environmental laws which are to be strictly implemented, which is what Justice Oak said in his judgment? Or are we okay with letting the government compromise with the entire scheme to bring about laws which can sort of completely take away the impact of these strict environmental regulations?
Right. So in fact, thank you for that. That's an interesting thought to take it forward because I'm trying to stick to the timeline as indicated by the MC. That, if you're looking forward and if you're looking at implementation as such where environmental, of course, is a very tricky topic, and of course, we can go on for hours of debates as to whether it has to be pro-commercialization vis-a-vis protecting the environment, and where do you draw the thin line. But if you look at, let's say, business operations in general, like if you're looking for growth, if you're looking for a success story, now that we're looking at the year 2026, I mean, we all see, various acts being consolidated, various outdated laws to be removed, like we heard about the labor law, we've heard about the consolidation of the criminal law, we're looking at AI. I want to throw this back to Rohit, that what do you feel would be most essential, or do you think would help us look at, let's say, from the information technology perspective, that what do you think would be the most useful going ahead to ensure a market which is better for growth?
First, I think I'd like to deal with the DPDP Act itself, because that is the first thing that is being implemented, and the compliance complexities is what will cause problems, especially for startups or smaller entities, because they'll increase their cost expenditure a lot, and the compliance complexities will deter them, and will be maybe good for us as lawyers, but it is something that and coming to the second part, what we are looking in the year 2026, we are hoping the digital bill is passed, and a comprehensive, robust act is there. Secondly, this for AI and for AI governing laws and DPDP, one thing we have to be very careful that we have to align them with global laws, because cross-border harmonization is very important, as we have seen in one or two instances where this North Korean group attacked Wazir X, and there's no answerability. Same thing happened, there was an Australian company attacked by American players, and the servers were used in some third jurisdiction. So the attribution is very important.
Right. So in fact, I recently attended a fintech event as well, and where there was a lot of discussion about like cross-border harmonization, and in fact, even from a regulatory standpoint, we in fact hear this at least in the insurance sector, that there is something called the regulatory sandbox, where you allow a propelling environment so that new players in the market are allowed to introduce products which will help them test the market, see how well it does, and basis the free playing field, if they're able to succeed, they are able to put that product in the market. And then I think cross-border transactions that are doing to that large extent, when you're looking at financial transactions there are lots of countries which are part of a network which are allowing this cross-border fintech products to come up. I think so that's a debate for maybe fintech, and I think we're not really touching upon that. But I want to put this to Shalini, that we keep talking about India to be the leader in the arbitration market, and want India to be pro-arbitration. There are so many events happening in India, day in, day out, from international events to daily events and the judges, the lawyers, who are all talking about that how India should be on the face of arbitration going ahead. Looking at 2026, what do you think India can do to make that impression stronger?
We are reaching there. I'll still not say that we are the hub. But of course, I think as a fraternity together, we are really trying very hard to be there to replace Singapore or maybe London-seated arbitrations or Paris-seated arbitrations. What is the most important factor here, as per me, is minimal judicial intervention. If somebody is going for ADR, it should be ADR and not a direct DR before courts, and not a litigation. We have seen a lot of changes in the laws, but we have also seen some judgments like DMRC Damel, which have really created a lot of distrust in the international community. And any international player coming to India will always bear it in mind that even if I get an award in my favor, what will happen? After years, when the Supreme Court in a curative petition reverses everything, and I go back to arbitration. So I think minimal judicial intervention is paramount here.
In fact, I want to bring in Sumer also on this, and I think the fact that in minimum judicial intervention, I think I believe you also worked on a case, or you've recently had the exposure of work or doing a matter where the modification of award took place, and you had something to say on that as well.
So you're right, Shalini, when you say that India wants to do a lot of things, wants to project a lot of things to the outer world. But unfortunately, look at what our courts are doing. And I can say it openly. I have legal luminaries behind me to fight a case in case there is one against me. But see, till today, the law was that once an award is passed, the courts will generally not interfere under 34. The courts would not modify that award. And that is a very important law which held the field till now. What has the Supreme Court done? The Supreme Court now says that we'll not follow Hakim and we will grant liberty to the court under 34 to modify the award. In exceptional circumstances, you may dress it up all you want, but ultimately today you've empowered under 34 courts to interfere with arbitral awards, and therefore I feel you have created one more ladder, one more step in the ladder, because in arbitrations, I mean, Section 11s go up to Supreme Court, Section 9 goes up to Supreme Court, an award is passed, that award goes up to Supreme Court. So how many battles will a person fight? So we really need a lot of introspection before we can actually call ourselves an arbitration hub.
Right. No, I mean, I don't want to, since we're litigators, we obviously are against judges, we're against the government, we are all, so I want to rather end this on a more positive note. And I think, before I go on to the next question, I think from whatever limited experience that I've had and understood, that I think the reason why Singapore does so well is because it is institutionalized to a great extent. And SIAC leads the field because it's thoroughly professional, it has full of experts, the timelines are very, sought after. It's not like the same litigating lawyers who are running to court the same day and doing an arbitration in the afternoon or later in the day. So I think and I think India is trying to push that, at least when we see that from DIAC or the other organizations that are coming up in the institutional way to kind of promote institutional arbitrations. And of course, at the same point of time, they are also promoting lawyers to be arbitrators in smaller disputes, not wanting to be just an old boys club, wanting to allow more experts to kind of be homegrown in this profession to allow faster results. I want to maybe bring Rohit back into this. Okay. Rohit, and like most other litigators, not very fancy talking, but I want him to jump into this again because, we may as well want to talk about something on the positive side as well. So, I mean, you are part of a fairly big firm, and so how do you see like ensuring more, I mean, to make offices more arbitration friendly? What are the steps that Solomon Hammurabi are taking to ensure Hammurabi are taking to ensure that there are more arbitrators, there are more arbitration friendly lawyers in your firm, or what are the steps just to ensure growth of arbitration in your firm?
We at Hammurabi are not taking adjournments.
To that. I think it's not just the laws. I think we as legal practitioners and professionals have also changed a lot. We are more accountable towards our clients. A hearing is done, you need to send a proceeding to your client, letting the client know that this needs to be done. We are also into specialization these days. So I think as professionals, the face of our profession is changing, right, which is amazing to witness, and I think 2026 has a lot to offer.
You want to add something, or should I go back to? So, I mean, of course, being professional, of course, I think as all stakeholders, we all would admit that it's equal responsibility for all of us to be as professional as possible, as diligent as possible towards our clients, and ensure that, the growth does take place. But I think other than that, is there anything which you feel, Sumer, as maybe not looking at arbitration, but in general, I actually want to take this question away from arbitration and want to talk about 2026 on another very positive aspect, is that, we all struggle with, since you're an environmental specialist, and since we all know that we all struggle with the pollution in our city, what do you think we can do to make this city a little more livable?
Just banning tandoors.
That certainly is not the answer. I hope I had a magic wand and I could do something about it. It is something very, very shocking. About 3-4 days back, I was hanging out with a friend, and he asks me in the evening, what are your courts doing to prevent this pollution? And I stepped back and I thought to myself, this is not the court's job. This is the regulator's job. This is the government's job. Because the government has failed so badly, had the court to step in, and it's been there since about 30 years now. We have living cases which are going on, Goda Varman, MC Mehta, they've been going on for over 30 years. Application after application is filed. Anyways, getting back to your question, I saw something in Ranchi day before I was there for a matter, and I think decongestion is what we need. Before we come up with a plan of making a new parliament, a new Supreme Court that is going to be built now, why don't we think of something constructive by taking these big institutions out of the heart of the city? I know it's Lutyens, I know it's not easy to leave, but if we don't think of these out-of-box solutions, I don't think anything is going to happen. Other than that, there is a lot of education that needs to go in. Our time's up. Yeah. I can see it in red, in fact. But yes, education is something that cannot be compromised with our day-to-day living. We need to have our lifestyle changes. I don't think I have any other solution for having better air quality in Delhi other than what I said. We need to decongest. We need to have better urban planning. This is not the court's job. Others need to step in.
Yeah, I think that's a good, fairly good final thoughts before we say bye-bye to this topic of State of Law 2026. I think, all the topics that have been touched by all the elite panelists today gives us this final conclusion that, it is a collective responsibility. There is, at some level, like we spoke about arbitration, that it's necessary for judicial interventions to reduce. At the same point of time, we spoke about an environmental law, that how it's the need of the hour for the governments to think out of the box. And I think somewhere down the line, if 2026 is going to be far more responsive, the responsibility is equally, I think faced with all of us as well. That, how do we see it? We want to take it forward, and as collectively, what are we doing to either implement or take forward the law in the right direction as we want it to be? Because there are lots of new laws that are coming through, right?
Sorry, just to add to that, we certainly don't need more laws. We have a lot of them. What we need is better implementation.
Yeah, so better implementation, and I think maybe it's time for consolidating them, because we've spoken about in labor law that there have been consolidation. We've spoken about in criminal law that there is consolidation. There is, if you ask anyone about whoever practices on the original side, CPC, I mean, every suit gets entertained, God knows for what reason. And there are judges who are saying that they're not equipped under the powers of 711 to strike them down or nip it in the bud on day one. Why is that? Because the laws today are not, thanks to all the creative lawyers who are sitting here, we can create any suit from anywhere, right? And that's only happening because the laws of our country is actually so outdated. I think maybe it's time for consolidating and swifter implementation by all of us who are collectively looking to, ensure things move in the right direction.
And simplifying. You don't need complications. Matters are complicated as it is.
Right.
Simplify the laws, keep it practical, move with the moving times is what is needed.
Right. So thank you all of you for listening to us, and thank you my elite panelists for contributing towards this discussion. Thanks.
Thank you so much, and thank you Varun for moderating that. Thank you.